So we will be talking about equal opportunity and the law, and talk about the HR and the company side, and talk about the employee side as well, and how each side tries to protect itself. So let me attempt again to share the screen. I had to stop this a minute ago and restart it. So I hope I am sharing the right screen here. Because it does not show something around it. So, okay. So every HR action that you take as a manager, from interviewing an applicant to training, appraising, rewarding them, has equal employment implications. So in this chapter, we provide you with the knowledge that deals with how to effectively deal with employment questions and protecting the employer and then helping the employee. So our chapter has 4 sections. We're going to talk about equal opportunity law. We're going to talk about quite a few laws. We're going to go through them pretty quickly. And then the EEOC that is set up to help employees who are being discriminated against or who have a complaint against an employer. And then we'll close with talking about diversity and inclusion. So we'll talk quite a bit about the Title VII of the 1964 Civil Rights Act. We also have executive orders, the Equal Pay Act of 1963, Age Discrimination and Employment Act of 1967, Vocational Rehabilitation Act of 1973. We have Pregnancy Discrimination Act of 1978. We have federal agency guidelines and early court decisions that all play into this. So the equal opportunity laws are laws that bar discrimination against minorities in the United States. These are nothing new. The Fifth Amendment to the US Constitution that was ratified in 1791 states that no person shall be deprived of life, liberty, or property without due process of the law. The 13th Amendment in 1865 outlawed slavery, and the courts have held that it bars racial discrimination as well. The Civil Rights Act of 1866 gave all persons the same right to make and enforced contracts that benefit people from US laws. But in a practical sense, Congress and presidents kind of avoided enforcing them until the early 1960s, when we had a lot of unrest, civil rights unrest in the US. And then at that point, both minorities and women started gaining traction and getting more equality. So Title VII of the 1964 Civil Rights Act actually got amended in 1972 with the Equal Employment Opportunity Act, EEOA, where they established the EEOC, Equal Employment Opportunity Commission. And it states that employers cannot discriminate based on race, color, religion, sex, or national origin. And it specifically states that it is unlawful and an unlawful employment practice for an employer to, number one, fail or refuse to hire or to discharge an individual or otherwise discriminate against any individual with respect to his or her compensation, terms, conditions, or privileges of employment because of the individual's race, color, religion, sex, or national origin. Number 2, to limit, segregate, or classify employees or applicants for employment in any way that would deprive or tend to deprive them of employment opportunities based on that list. And then the Equal Employment Opportunity Commission has the responsibility to administer and enforce the civil rights law. And it consists of 5 members that are appointed by the President of the United States. Then various US presidents have signed executive orders that expand equal employment in federal agencies. So there are a lot of regulations that regulate any agency or any company that does business with the US government. So the Office of Federal Contract Compliance Programs oversees anyone who does business with the US government. The Equal Pay Act of 1963 tried to put laws in place to give equal pay to minorities and women, and that we cannot discriminate pay based on sex for equal work that requires equivalent skill, effort, and responsibility, and under similar working conditions. This is very sticky because there are industries that women and minorities are still at like 63 to 85 cents to a dollar on the dollar, and still severely underpaid. So there are constant issues with this act, and proving that people are still being discriminated in this area. One of the difficulties here is that they will say that women, for example, have chosen to get paid less because they've taken time off of work and therefore are not eligible for the same promotions. So for example, when I had my first child, I continued to work for the next 14 months after she was born. And then I took 8 years off. And I did contract work. I did volunteer work. I had my own consulting business that was part-time, but that was a gap by employment where I was not earning, even though I had my own business. I was working it part-time because I was focused on raising my children. And so when I went to re-enter the workforce, I was way behind men who had worked through those 9 years of their lives. And so they will say, well, you're behind pay-wise compared to men of my age because I chose to exit the workforce. And so there's a lot of issues like that. But that doesn't excuse it for minorities who have continued to work hard and who are still behind. So we still have a lot of issues like that that need to be worked through in our Equal Pay Act. Age Discrimination in Employment Act of 1967 is abbreviated as ADEA. And it states that no discrimination should be allowed for people between the ages of 40 and 65. And basically, there should be no slack for employers if they fire an employee and replace them by someone much younger. So that is to protect an older category. Vocational Rehabilitation Act. So if you have a federal contract of $2,500 a year or more, you have to provide employment or make accommodations for handicapped workers. And then if you have employees, 15 or more employees, you must comply as well. And then some states have lowered that. So like the state of Colorado lowered it to 10 employees. Pregnancy Discrimination Act prohibits employers from using pregnancy, childbirth, or related medical conditions to discriminate in hiring, promotion, suspension, or discharge of an employee. That is very, very difficult. And there are more and more women who are suing under this act. The federal agency guidelines. So the EEOC was created. The Civil Service Commission was created as well. The Department of Labor and Department of Justice try to maintain certain levels, and they set standards of record keeping and employee selection and pre-employee employment inquiries that have to be done. And they set up this uniform guidelines to help employers stay within appropriate guidelines. So there are some court decisions. Please read up on these, like Griggs versus Duke Power Company. This had to do with discrimination does not have to be overt to be illegal. And this was about requiring a high school diploma, and you have to prove that that is necessary. And then Albemarle Paper Company versus Moody. They made the job performance standards should be clear and unambiguous. And you must document that the screening tools have to be clear. So if you require a test, it needs to meet the criteria for that job. So you can't require a personality test of one person, not another. And if the personality test isn't relevant, you can't require it for that job. So there's things like that got written into that law. Employment laws that have come into existence in the last 30 years. There's been quite a bit of movement. So we have the Civil Rights Act of 1991. We have the American Disabilities Act. We have the ADA amendment. We have Uniformed Services Employment and Reemployment Rights Act. We have Genetic Information Non-Discrimination Act of 2008. So the Civil Rights Act of 1991 put the burden of proof in the hands of the employer, because employers are going to have more resources than the employee. It reduced money damages on the employee side. The employee has to prove that they were hurt financially, and they can't tag on thousands and millions of dollars if it's not proven that they suffered that much. And then, let's see, mixed motives. So even though their actions were discriminatory, other factors like the employee's dubious behavior made the job action acceptable. If there is any such motive, the practice may be unlawful. So really it puts the burden on the employee to be above the law. Okay, so then, the Americans with Disabilities Act added mental impairments to the ADA, and you have to have the employee has to be qualified for it, and then you have to make reasonable accommodations for that employee. And I'll have you guys go ahead and read the guidelines on your own. The Uniformed Services and Employment and Reemployment Rights Act basically is protecting our servicemen and women. And when they come back to the US or when they leave the military, employers are expected to reinstate them in similar pay positions. Genetic Information Non-Discrimination Act basically protects you so that you cannot be discriminated against or refused insurance or things like that based on your genetic information. And it increased your confidentiality. So like if it's required for your, like if a physical is required or GNA testing is required for your physical, it cannot come back to the hands of the employer, and that data cannot be used against you. So states have added their own layers of laws. So companies do need to check into what the states require. And like, for example, on the American Disabilities Act, the US government says companies with 15 or more employees, and Colorado says 10 or more employees. So you need to check into things like that. We have had a lot of religious retaliation, especially after 9/11. And so there's been a tightening up of laws to protect discrimination based on religion. And then we've had other things that have come up, like definitions needing to better define the rules around same-sex marriages and the definition of spouse, or what retaliation means, and what the definition of a supervisor is, or even like Michigan's affirmative action for college admissions came up in to be studied, and things like that. So this is an area that is constantly in motion. And then the internet has added other layers like zero tolerance policy on bullying and cyberbullying and things like that. So sexual harassment is a whole other category that we could spend hours and hours and hours on. Companies are required to have sexual harassment policies. And as of, summer 2020, there has been a very heightened awareness, and actually the US went through a major shift where now the training that is required annually in corporations is sexual harassment and inclusion as well. So diversity and inclusion is actually the new terminology that is used across the board, and the laws require that employers train employees on an annual basis on diversity and inclusion, and sexual harassment is part of that. So there's the Federal Violence Against Women Act of 1994. So the Title VII, sexual harassment generally refers to harassment on the basis of sex, when such conduct has the purpose or effect of substantially interfering with a person's work performance or creating an intimidating, hostile, or offensive work environment. In one recent year, the EEOC received 11,717 sexual harassment charges. About 15% of them were filed by men. In 1994, the Federal Violence Against Women Act was formed, and it further provides that a person who commits a crime of violence motivated by gender and thus deprives another of her rights shall be liable to the party injured. So the EOC defines sexual harassment as unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that takes place under any of the following conditions. 1, submission to such condition is made either explicitly or implicitly a term or condition of an individual's employment. Number 2, submission to or rejection of such conduct by an individual is used as the basis for employment decision affecting that individual. Number 3, such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive work environment. Okay, so there are 3 main ways someone can prove sexual harassment. 1 is quid pro quo. So the most direct way is to prove that rejecting a supervisor's advances adversely affects what the EOC calls tangible employment action, such as hiring, firing, promotion, demotion, and/or work assignment. The second one is hostile environment created by supervisors, and the harassment need not have tangible consequences such as demotion. And then a hostile environment created by coworkers or non-employees. So coworkers and non-employees can trigger such suits, okay? And this could be like, it could be like the UPS person that comes in, okay? And makes it a hostile environment. It can be your coworker. So when I was doing sexual harassment training for corporations, I was asked to do training in a network of clinics, of medical clinics. And they had a doctor who would post cartoons in his office. And his cartoons were like, they were funny to him, but they were mortally embarrassing to his patients. So the patients found them demeaning, they found them embarrassing, and they were like medical jokes about body parts, about the physicals. They were demeaning of patients, and this doctor thought it was hilarious, and he would blow them up and post them. And there was HR director had talked to him. There were complaints filed, and this doctor thought, I'm above the law, I'm a doctor. And they were facing a lawsuit, and the doctor was like, I don't care. Why they hadn't fired the doctor, I have no idea. But they asked me to come in and do the training because they wanted an outsider doing the training. And then on top of the outsider doing the training, I was asked to do like a visual visit of the environment to try to discover on my own where the problem areas were. And there were several that I had been made aware of in advance that I need to go and discover. And basically, I wrote them up and told them that I would turn them in to the EOC, that I was required to turn them into the EOC for this doctor's behavior. inappropriate jokes and stuff. And his nurses would quit left and right because he made inappropriate jokes to them all the time. And as a result, he quit. He went to work somewhere else. And then, you know, it's a small town, word gets out, right? So pretty soon people are like, well, why did he quit? And the HR director couldn't say anything. And so people knew that I was a sexual harassment trainer and that I was connected to that system. And so they were like, so you tell us the scoop. And I'm like, I can't. I really can't tell you what the problem is, but I'm sure you'll find out. And that's all I said. I'm sure you will find out. And lo and behold, in the matter of literally less than 6 weeks, his jokes were up, and that HR office had zero tolerance. And because it was within his 90 days, they fired him on the spot. They were like, zero tolerance. We are not even asking you. We are informing you that that comes down right now. And he gave them an attitude and they marched him out. Like they literally marched the doctor to the car and said, get out of here. So, you know, people are not above the law. So when is an environment hostile? Generally when it is intimidating, insulting, or it is ridiculing people, okay? So the Supreme Court, I mean, you can read, there are quite a few cases, and of course their cases are ongoing. And honestly, the law isn't enough. Not everything can go into the law, and people need to protect each other. People need to rally together. So they say that okay. Women perceive a broader range of social sexual behavior touching, for instance, as harassing. In one study, 58% of employees reported experiencing potential harassment type behavior at work. About 4 times as many men as women found that the behavior was flattering or benign. And sexual harassment training and policies can reduce this problem. Second victims are often fearful, and third victims often won't complain. And then finally, neither harassment training nor HR departments are always helping. So what employees can do, first of all, complain. And remember that the courts first will look at, did you complain? And did you file a report promptly? It doesn't matter if you file it months from now, they want it to know that you took action immediately. So speak with the harasser and or his boss, stating the unwanted overture, that it's unwelcome. Number 2, inform your own supervisor. If the unwelcome conduct does not cease, file a verbal and written report regarding the unwelcome conduct and unsuccessful effort to get it to stop with the harasser's manager and the human resource director. Number 4, if the letters and the appeals to the employer do not suffice, then you contact the local office of the EEOC and you file a claim. And unfortunately, people don't go to this level because frequently the intimidation is such that people lose their job. And it takes months and sometimes years. And the person needs a job. And so they end up backing out. It's a really unfortunate situation, guys. Okay, So defenses against discriminatory practices and allegations. So disparate treatment or intentional discrimination exists where an employer treats an individual differently because that individual is a member of a particular race, religion, gender, or ethnic group. So an example would be a rule that says we don't hire drivers over 60 years of age, okay? And disparate impact, an employer engages in employment practice or policy that has a greater adverse impact or effect on the members of a protected group. So, what do you do, right? So you have to show adverse impact. So it's very difficult to do. So you have to be able to compare application rejection rates for minority and non-minority groups. Unfortunately, with a private company, you can't get a hold of that data. They will, although they can look at standard deviation rule, so the statistical difference between the numbers of minority candidates, you would have expected to hire versus how many you actually hire. You have a restricted policy that would exclude people, or a population comparison. Let's say that your population has, I don't know, 60% minorities and only 15% of the minorities are employed in your company, then it's obviously that there's a problem. So you can do those population comparisons. And then the McDonnell-Douglas test has 4 rules that must be shown by a potential employee. Number 1, a person belongs to a protected class. Number 2, an applicant was qualified for an open position with the employer. Number 3, despite being qualified, the applicant was rejected. And 4, after rejection, the position remained open and the employer continued seeking applicants with a complainant's qualifications. So if they hire someone else and fill the position, it's a lot harder to prove. But if they reject you and don't hire someone, then you could have cause. The bona fide occupational qualification. So an employer can claim that the employment practice is a bona fide occupational qualification for performing the job. So it should not be an unlawful employment practice for an employer to hire an employee on the basis of religion, sex, or national orientation. In those certain instances where the religion, sex, or national origin is a bona fide occupational qualification reasonably necessary to the normal operation of that particular business or enterprise. But this is very narrowly defined and you've got to be very careful with that. Then there's business necessity, is a defense created by the courts, and it requires showing that there is an overriding business purpose for the discriminatory practice and that the practice is therefore acceptable. So steps in the EEOC enforcement process. Take some time and study this chart. It's way too small here for you to be able to really see it. But here are here's the process. Number 1, you file a charge. The committee looks it over and the charge is accepted. They serve notice to the company. There's an investigation, fact-finding conference. They then rule that there is a cause or no cause. Then they hold a conciliation meeting and then a notice to sue. Voluntary mediation is an informal process with a neutral third party. for voluntary negotiated resolutions of fixing that charge. And about 10% of its charges go to voluntary mediation. Then you've got mandatory arbitration of discriminatory claims. This is an alternative dispute resolution process, and many employers would rather do this rather than go through EEOC litigation. So it is an alternative, and it is a dispute resolution process with binding steps that you must take once that decision is made. So diversity and inclusion and attitudes that undermine it. So diversity is what? It means being diverse or varied. And at work, it means having a workforce composed of 2 or more groups of employees with various racial, ethnic, gender, cultural, national origin, handicap, age, and religious backgrounds. So we will talk about diversity throughout the book, but this, as you know, has become a central focus of our companies today in the US. Workforce diversity produces both benefits and problems for employers, and it can produce problems. So some potential problems could be stereotyping, where people kind of just make generalizations. So older people don't know the internet and they can't do their job, okay? So stereotyping, or discrimination, that is a prejudice against someone based on their status, or tokenism. A company appoints a small group of women or minorities to high profile positions. You know, we've got our token minorities, and I've seen that happen in companies, and it's scary. It's sad, actually. Ethnocentrism, because it's actually in the long run, it's a put down to the minorities that they hired. It's not solving anything. It's not really empowering them, and so on. And then ethnocentrism is a tendency to view members of other social groups less favorably than your own. So how do you manage diversity? There are huge benefits to having a diverse workforce. It does make for more innovations, more creativity, better, so much, but you do need to know how to bring out the best. And if you're not trained in that area, you can have a lot of struggles, a lot of problems. So there are some top-down diversity management programs. The strong point about this is that people look up to administration, and if your administrators are very strong diversity leaders, then they're setting the tone and the culture. They can assess the situation. They can provide or endorse diversity training and education. They can provide a guideline for changing a culture, and they can evaluate the diversity management program that gets established. Affirmative action means that you put in place programs that will help eliminate the effects of past discrimination in processes like recruitment, hiring, promotions, and compensation, but it does require a lot of consistent training. So there are steps that you can take in an affirmative action program. So first, issue a written equal employment policy that indicates that the firm is an EEOE employer and the employer's commitment to affirmative action. Number two, you can demonstrate top management support for equal employment policy. Number three, you can publicize internal and external equal employment policy and affirmative action commitment. Number four, you can survey current minority and female employment by department and job classification to determine what levels you're at and how to make improvements. Number five, carefully analyze employer human resource practices, identify and eliminate hidden barriers. Number six, review, develop, and implement specific HR programs to improve female and minority utilization. 7, use focused recruitment to find qualified applicants from the target groups. Number 8, establish an internal audit and reporting system to monitor and evaluate progress. And then 9, develop support for the affirmative action programs inside the community and in the company. And then there is reverse discrimination, which means discriminating against non-minority applicants and employees, claims that due to affirmative action systems, white males are discriminated against. So that takes us through the end of this chapter, and I hope it's given you a solid overview. I know it's a lot of material, but it's well worth it. This chapter is well worth it.